Good morning, everyone. Welcome to another episode of Spilling Tea. I am your host, Tiffany Daniels, and a very decidedly not stupid o'clock to one and all. We are going back to that horrible world known as the JRC. But before we get started this morning, a few of the usual disclaimers. First off, you are going to find the link to this train wreck of decision made in 1988 that the Judge Rotenberg Center has used ever since then as a license to torture, abuse, and traumatize disabled people right there in the description box, alongside the other pertinent links to the Stop the Shocks campaign, including Autistic Hoya's massive archive, where you will find that is where we get the majority of our source material for these videos. Alongside it, folks, we have the templates. Sign your name, click on your senator. We are trying to end all adversive treatments, punishments for people being neurologically disabled, and also trying to stop improper restraint in schools. Folks, this has cost lives, especially improper restraints, every single year. So please take 2 minutes out of your busy day to go ahead and assist us, all right? We also have the ever-present change.org Shut the Judge Rotenberg Center Down petition. Because, folks, ever since this document we are about to go over today has come out, they have been able to somehow win on appeal on every single lawsuit that has come their way. They've been getting away with this since 1976. And at this point, folks, us advocates who've been fighting these bastards, we're tired. We're exhausted. And the only real way that we can see to actually protect these kids is to bring this school to a close. So please share that petition on all your social media. Now, when we're talking about the Judge Rotenberg Center, you're going to hear vivid descriptions of, as well as see surveillance clip footage of, people with disabilities being tortured and abused. If you have young children present, please use your headphones. Also, folks, this is a very pertinent case and goes into how the JRC has continued to get away with this for so many years. So, if I stumble over my words, start screaming out obscenities, or stare off into space, my apologies in advance. Now, let me give you some background. This is involving a lawsuit many years ago. It has to do with the death of one of the students at the JRC due to their quote-unquote treatment programs. The judge who made the decision is the individual for whom the center is now named. Originally, it was named the Behavioral Research Institute. So, this is very pertinent and goes deep into what the JRC has used for so many years to continue their barbarous practice against people with disabilities and mental health issues. So, let's go ahead and get into it. This is going to be 17 pages long, folks. We're not going to go through all of it today, but we're going to go ahead and read over it. So, as you can see, it is called BRI here. Behavioral Research Institute. Dr. Matthew L. Israel. Leo Soucy, individually and as parent and next friend of Brendan Soucy, Peter Biscardi, individually and as parent next friend of PJ Biscardi, and all parents and guardians of the students at the Behavior Institute, on behalf of themselves, their children, and wards. You see, They have been brainwashing these parents for a very long time for reasons that are mystifying to me. Somehow they have always have had this group of core parents that just absolutely 110% believe in what they're doing at this school, in spite of all the evidence and in spite of the 6 people who are dead. Now, let's see who the plaintiffs are. Mary Kay Linder, individually and in her capacity as the director of the Massachusetts Office for Children. Defendant. Preamble. Here we go. On September the 26th, 1985, the Massachusetts Office for Children, OFC, issued an order to show cause why the license of the Behavioral Research Institute should not be suspended, revoked, or otherwise sanctioned for various violations of OPC's regulations. Since that time, the parties of OCFC, BRI, and parents of the clients attending the BRI have engaged in a multitude of lawsuits and administrative proceedings. This is in regards to the 6 dead students. The parties, for the benefit of the clients attending BRI, now intend to resolve their differences and end the litigation. That should have never happened. I would have gone. There would be no way in hell, nothing that the JRC can ever offer me that will ever make me stop. Just saying. Administrative and judicial between them. For that reason, the parties enter into the following agreement, which is made for this case only. See, if I could highlight that, I would. This was supposed to be for this case only, but the JRC has used this settlement agreement as justification for what they do at their center ever since. Ever since. And that is in spite of the ever evolving and changing different kinds of treatment programs that have been popping up quite literally ever since. Ever since. And yet they use the same defense and lines and lies that they've been using all the way since back during this lawsuit. Interesting, isn't it? By entering into this agreement, none of the parties admit liability or concede the truth of the allegations made by the other party. So, the parents that were fighting the JRC for the death of their kids still maintain, at least by the time this agreement came out, that the JRC are 100% liable for the death of their children. Let that be noted. The sole intent of each party is simply to resolve this case and the other administrative and judicial cases which are now pending between OFC, BRI, and the parents. Substituted judgment for adversive procedures. Adversive procedures are permitted for use at BRI only when authorized as part of a court-ordered substituted judgment treatment plan for an individual client, when such client is either a minor or is not able to provide informed consent thereto. Think about this, folks. Think about it. It's been years and years and years, and we have come up with numerous treatment plans. I mean, ad nauseum. Media, in case you're wondering, literally ad nauseum. Person-centered planning, which was the type of program that I was involved in starting my last few years of high school, not long after my diagnosis, being one of the most prevalent to come out of the late 90s, early 2000s. There is positive behavioral reinforcement. There are tons and tons of other types of treatment programs and plans, and yet they still rely on this judgment. Why? This judgment to me seems, from the get-go, to allow for the evolution of medicine and treatments to supersede any decision to send these kids to this school. And yet they still use it. This particular judgment here to justify using adversive procedures and treatment plans, which is a code word, by the way, for punishing people for being disabled and acting within the parameters of how our brains fire. Yeah, moving on. As used here in the term adversive procedures should include all adversive procedures which are presently used or which may be proposed for at BRI, with the exception of the following. Okay, let's give you a little bit more context here. This is in 1988, before they introduced the GED devices. During this time, it was permitted not only for the JRC, but other treatment schools and institutions at the time to use things called such as face masking, where they would literally put a cloth over the disabled person's hand, pull it back behind their head, and hold it tight until they stopped. Spraying water in the face, pinches, slaps, hits with spatulas, full body restraint with a body laying over that of the disabled person. The list goes on and it's quite horrific. Okay, moving forward. No, ignore, token fines, and any other procedure found by the court after hearing not to require substituted judgment. Nothing in this agreement shall preclude the BRI from developing new reward and aversive procedures. See, this right here is what they use as justification for them to have developed the GED and to use it to torture disabled people. Okay? Get that through your head there. For all clients, BRI shall propose those treatments which are the least intrusive, least restrictive, modulates appropriate to each client's needs. This is where the JRC fails from 1988 to this very day. Listen to this sentence. The least intrusive, least restrictive modulates appropriate to each client's needs. Think about it and think at what they do. It makes it interesting that they use this settlement agreement to actually defend themselves, when if you read the actual document in itself, it's just very interesting is all. For purposes of this section, physical aversive procedures such as spanks, pinches, and muscle squeezes, and restrained time out shall be considered the most intrusive, most restrictive forms of treatment. Thank you for correcting me. They were using more physical abuse like we would see in how you have abused children treated back then. Prior to intake, BRI shall formulate an interim treatment plan based upon clinical information received from the referring agency. The following procedures shall be followed upon the client's arrival at the BRI. Where the client is an adult and able to provide informed consent to such interim treatment plan, the plan may be implemented upon his or her acceptance of its provisions, provided, however, that before said plan is implemented, DMB shall be notified and shall be afforded the opportunity to evaluate the student. In the event that the student's ability to provide such informed consent is doubted, a petition for the appointment of a temporary guardian shall be filed. Very telling, isn't it? The majority of the students at the JRC are not their guardians. They even they either have a court-appointed guardian or it is being decided for them on their parents. These people that are at that school are given no rights and are more often than not, when put on the GED, decided to be too incompetent to make a reasonable decision about themselves. Funny, isn't it? Sad and psychotic. But moving on. Where the client is a minor, that portion of interim treatment plan which does not involve use of adversive procedures or extraordinary procedures determined to require substituted judgment by the court may be implemented upon the parent's acceptance of its provisions. That portion of the interim treatment plan which involves the use of adversive or extraordinary procedures may be implemented only upon the authorization of the court in a temporary guardianship proceeding for, upon motion, to modify an existing guardianship order, utilizing the substituted judgment criteria. Moving on. Where the client is an adult but is unable to provide informed consent to the implementation of the interim treatment plan. And the JRC, they bend over backwards to make sure we are declared incompetent. Because when we are declared incompetent, they can either A, rely on the judges whose pockets they line to appoint a friendly so-called temporary guardian to go ahead and agree to this crap. Think about it. Or they brainwash these parents and making them think that the only way to save their children from the horrors of medicine is to allow them to torture us. I've said it once, I'll say it again. If there's a choice between this shit or being electrically shocked or the meds, I'm going to take the meds. I'm going to take the meds every time. And here's the thing, especially from 1988. What they refused to do in the state of Massachusetts is evaluate and understand that pharmacology has advanced leaps and bounds since the time period of 1988. It is no longer likely that when using pharmaceuticals in treatment plans that the kid is going to be drugged out of their gourd to the point they're a vegetable and cannot function. Look at modern medicine. Open up your eyes. We're talking over 30 years ago, and they're still using the same arguments, and people are still buying it. Medicine has evolved. Pharmacology has evolved. Treatment plans has evolved. But the JRC and the parents who defend it, the legislators who make the laws, the professionals who sign off of it, and the judges who court order it, they have not. And the question becomes, why? Moving on. That portion of the plan which does not involve the use of adversive or extraordinary procedures may be implemented upon its acceptance by a temporary guardian appointed by the court. That portion of the plan which involves the use of adversive or extraordinary procedures may be implemented only upon the authorization of the court in a temporary guardianship proceeding, or upon motion to modify an existing guardianship order utilizing the substituted judgment criteria. Again, BRI shall formulate a treatment plan within 45 days of a client's arrival at BRI. Upon formulation of such a plan for a new client, and regarding the treatment plan of a client presently at BRI, the following procedure must be followed. Where the client is an adult and is capable of providing informed consent thereto, the treatment plan may be implemented upon his or her acceptance of its provisions, provided, however, that before plan is implemented, DMH shall be notified and shall be afforded the opportunity to evaluate the student. In the event that the student's ability to provide such informed consent is doubted, a petition for an appointed permanent guardian shall be filed. Let me put that in layman's terms. If the person completely disagrees and says, no, I will not go here and accept this insane idea you all have for treatment, then the JRC will then provide their own doctors and physicians, have that person declared incompetent, put them in the hands of a court-appointed guardian who will then force them to go through it. Just saying. But a client is a minor. The portion of the treatment plan which does not involve the use of adversive or extraordinary procedures may be implemented upon the parent's acceptance of its provisions. That portion of the treatment plan which involves the use of adversive or extraordinary procedures may be implemented only upon the authorization by the court in his permanent guardianship proceeding, for upon motion to modify the existing guardianship order utilizing the substituted judgment criteria. You see what I mean? We're not given any real choice. They just like to make it look like we have some sort of choice before they yank that away from us. Moving on. Where the client is an adult but is incapable of providing informed consent to the implementation of the treatment plan. These are the kind of folks that would have had someone like me declared incompetent in spite of myriads of evidence to the contrary. You have no idea how much power this one institution wields in this state. It is the stuff of nightmares. And I can't help now but to thank God and everybody up there in the hierarchy, celestial, whatever, that likes me, that I was not born in this state. Just saying. That portion of the plan which does not involve the use of adversive or extraordinary procedures may be implemented upon its acceptance by a guardian. That portion of the plan which involves the use of adversive or extraordinary procedures may be implemented upon the authorization of the court in a permanent guardianship proceeding, or upon the motion to modify an existing guardianship order utilizing the substantiated judgment criteria. Think about it, guys. Look at this document. It pretty much tells us the client, adult or not, is completely powerless. If that person who has their own autonomy says no, the JRC has them evaluated by their own physicians and declared incompetent and forced to undergo it anyway. If they are minors, then they convince the parents to do it. If they can't convince the parents, well, then they have the parents declared incompetent and then put in a court-appointed guardian. Don't believe me? Think I'm talking out my ass there? Look at the students from New York. And by the way, folks, look at the people they bring into the JRC. 75% come out of poor communities. 75% are people of color. They target those areas with low accessibility to alternative treatments. See, instead of this concept of building an infrastructure into those areas to improve access to more coherent and modern treatment programs, instead they get sent here to this hellhole. If that is not racism and elitism, I don't know what the hell is. In any substituted judgment proceeding in which authorization to implement adversive extraordinary procedures is sought, the petitioner shall present, in addition to evidence concerning the client's inability to provide informed consent to such procedures and the client's present and psychological and medical circumstances, evidence of the following. The target behaviors to be targeted by means of such adversive or extraordinary procedures and the clinical reasons why non-adversive or less intrusive adversive procedures are inappropriate. a full description of the procedures to be followed in the treating such as target behaviors at the BRI school facility. So that's the beginning of the language of the targeted behaviors or pinpoints. At the school's residence in transit, on field trips, the process and period of time by which the implementation of such procedures is to be monitored, and the method by which the effectiveness of such procedures is to be determined. The reasonably foreseeable adversive side effects, if any, associated with the use of adversive or extraordinary procedures, the likelihood that such side effects will occur, and the likely severity of such side effects where they to occur. The professional disciplines of the staff members who will implement such adversive or extraordinary procedures, as well as supervision and training such staff members have had and will receive. Think about it. They literally use discipline. Discipline. We're going to beat the autism out of them. We're going to shock it out of them. We're going to starve it out of them. Yeah, that's the logic we're operating off of. Logic we are operating off of is over 30 years old. Just saying is all. The client's prognosis should rate such adversive or extraordinary procedures be implemented. The client's prognosis should such procedures not be implemented. The opinions and concerns of the client's family and the impact upon the family were the adversive or extraordinary procedures not to be implemented. Okay, so this is where we go to the crying family members, okay? What do I mean by that? Am I trying to be completely cruel to the family members? Absolutely not. Absolutely not. But you're talking to someone who's had to deal with these parents that literally use whining about their kids' autism and turn it into a goddamn career. Okay? Parents who have said on camera that they want to get into their car and drive themselves and their child off a bridge, kill their child. And I am supposed to trust that these parents can make the best medical decisions on their child's behalf. And when I dare say anything about it, I get the famous, "You don't understand. You're not like my child." Maybe, maybe not. And I understand that there are people who have different challenges than me who are at other places in the spectrum. I am not stupid. Remember, I have worked in this field. I understand. And my heart does go out to the families, to the parents. But of all the parents I have worked out here with in the state of Missouri, on the mentor to mentor program and in a professional capacity, not a single one of them would ever agree to send their child to this school. Period. Even the parents who to this day argue with me kindly. It's not like we're like ripping each other's throats out, but kindly and vehemently disagree with my stance on ABA. Even those parents whose children, yes, I'll agree, are different from me. I'm more like them than their parents are ever going to be, but still, I digress. When you talk to them about this school, recoil in horror. Just putting it out there. The treatment previously provided the client at BRI and elsewhere, and the clinical assessment of its results. A description of the client's appropriate behaviors, if any, and the procedures to be implemented to reinforce them, which the description shall include appropriate functional communication behaviors, and behaviors incompatible with the targeted inappropriate behaviors. This garbage idea of using behavioral modification on someone with a neurological disorder, which is the height of stupidity and intellectual idiocy. I'm going to call it intellectual idiocy. This concept that if we just train the behaviors out of them, that doesn't work when you're working with a neurological disorder because it is not a willful behavior. Maybe corrections in behavior might be a system that would work if the behaviors are willful. When you're dealing with neurodevelopmental disabilities, it's not willful behavior. We are not deciding to do these things. They are a natural output that comes from our particular disability. So punishing us for them and trying to point out what you consider appropriate behaviors is not going to work. It is the height of intellectual arrogance, and I hate to say it, the height of privilege. But moving on. The client's current IEP or ISP. Any other information requested by the court. The Department of Mental Health DMH shall be notified of the referral and acceptance by BRI of any clients as soon as it is practicable. Where appropriate, clinicians of DMH shall review the information received from the referring agency and advise the court of their treatment recommendation in temporary guardianship proceedings called for in Section 4 above. Prior to the hearing or a treatment plan for a new or current student called for in Section 5 above, DMH clinicians shall evaluate the client's clinical circumstances and shall provide the court with their recommendations on the issues noted in Section 6 above, as well as their assessment to the client's ability to provide informed consent to treatment. Okay, here's what I find interesting, and here's my question. If the physician is the one who's determining the student, comes from the JRC, are they actually going to provide alternative treatment plans that can be found outside the JRC when the JRC is in fact their employer? Think on it. They're going to act within their own best interests. And remember, these kids are literally worth $285,000 per year per head. Now think, are they really going to present to the judge a possible another effective treatment plan? We call it out here in Missouri, we call it evidence-based. Evidence-based treatments. Stuff that has been proven to work over many, many years. Out here, we don't approve of any other plan than those that we can guarantee are actually evidence-based. These are not evidence-based treatments. Not at all. Especially since the only school providing data on it is the JRC, because literally every single state has declared it outdated and barbarous and have evolved with the times to the other treatment plans out there. Yes, even the pharmacological ones, because believe it or not, pharmaceutical medicine has advanced incredibly so since this decision was made. But moving on. DMH clinicians shall submit their report to the court within 10 days, if practicable, but in no event more than 20 days following the receipt of the BRI's treatment plan. Such clinicians shall be available for consultation with the guardian ad litem, court-appointed monitor, court-appointed counsel. See, not student-appointed counsel. Yeah. BRI shall cooperate fully with the DMH clinicians and shall afford them full access to each client his or her record, and the BR staff working with the client. Okay, folks, we're going to move on to the next part of this judgment tomorrow. But I want you to pay attention to it, because the JRC has used this particular settlement as what they call the consent statement, as a reason to continue, as a means to continue. And this is the judgment that they cite in this settlement whenever they continue this horrible, barbaric practice of torture as medicine to this day. So it's going to be very interesting to continue to go over this settlement statement. Keep your eye on these videos. All right? And on that note, we're going to go ahead and close out for this morning. We don't get very many views on this channel, especially on this subject. The few that we do get do tend to get removed from time to time. So folks, please don't forget to hit that like button. Hit subscribe. Don't forget to hit the comments. I do appreciate your time this morning. And as always, we here at Spilling Tea hope you have a good one. Bye-bye.